Over the past year, in my travels across the country on my speaking tour to promote my book, Tug of War, it became very clear to me that there's a lot of confusion and misunderstandings out there about the law of child support in Canada. So I thought I would dedicate our very first episode to the topic of child support. I'm going to try my best to explain as simply and as clearly as I can the basic principles governing this very important aspect of family law. Obviously, I can't cover every possible situation, and this broadcast should be seen as a general information session, not legal advice. For specific and reliable legal advice about your own personal circumstances, you should always consult a family law lawyer. Here's a little bit of background that you may not have known about. Before 1997, judges had the discretion to decide the amount of child support to be paid, based on the needs of the child and the parent's financial circumstances. There was great inconsistency between judges, and many people felt there needed to be a more standardized, objective approach, which would hopefully reduce conflict between parents and reduce litigation by making the calculation of child support easy and predictable and efficient. The United States has been using child support guidelines for many years, and this concept was eventually introduced across Canada in 1997. And so, child support is determined in accordance with the child support guidelines. Here's how it works. The amount of child support you pay is based on the payor's annual income and the number of children in the family unit. Every province has its own child support tables that tell you the amount of support that you have to pay. In the vast majority of cases, to find out how much child support you should be paying every month, start by going to the tables for your province or territory. You can get this information online from the Federal Department of Justice website at www.justice.gc.ca. When you get on that page, click on Supporting Families. Then click on Federal Child Support Amounts, Simplified Tables. Then click on your province or territory and the tables will appear. Here's an example of a page from the Ontario tables. You'll see that if you earn $16,900 per year and you have 2 children, you're going to pay $265 a month in child support. The table amount applies to each family unit. So if you've had more than one relationship and your children are living in separate households, you pay the table amount for the number of children in each unit. You cannot total up all of the children you have and then divide the total amount between all of your ex-partners. So for example, if you have 1 child with ex-partner A and 2 children with ex-partner B, you pay the table amount for 1 child to ex-partner A and the table amount for 2 children to ex-partner B. How do you determine your annual income? You refer to your income tax return and notice of assessment. On your income tax return, look for the line that says total income. Your income for child support purposes includes money earned from employment, and that could include salary, wages, commissions, and possibly bonuses, and also self-employed earnings and income from investments. Even employment insurance and social assistance are included as income for child support purposes. If you're unsure about whether money you have been receiving should be included in the calculation of your income for child support purposes, you can consult the Federal Department of Justice publication called The Federal Child Support Guidelines Step by Step, and you go to the Federal Department of Justice website that I've already mentioned. And of course, you should always consult a family law lawyer. Sometimes it's difficult to know what a support payer's true income is for child support purposes because of certain unique situations. For example, if the payer's income fluctuates greatly from year to year for legitimate reasons, the court may take a 3-year averaging approach. Some business people incur non-recurring capital or business investment losses, and so sometimes it's necessary to make adjustments to arrive at an appropriate and fair amount that reflects the parent's true ability to pay. Another example might be where a support payer owns a corporation and receives money from that corporation. The court may need to pierce the corporate veil if the payer's income that's reported on his or her income tax doesn't fairly reflect all of the money available for child support. Sometimes a parent's income is low for inappropriate reasons. The law expects parents to act reasonably when it comes to earning a living, so they can support their children to the best of their abilities. If a parent is intentionally unemployed or underemployed, or is deliberately manipulating their finances in such a way as to appear to have less money than they actually have, or if there's other circumstances where a parent's income tax documents just don't give a true picture of the person's financial situation, then the court can impute or attribute income to that person, which means that the judge will treat the person as if he or she actually earns more money than they are saying that they earn. In other words, parents have to support their children according to their capacity to earn a proper income, which is not always the same thing as what they're actually earning. And I'm sure you would not be surprised to learn that if a payer has failed to provide the other parent with the required proof of income, then the court can draw a negative inference and order child support in an amount that the court considers to be fair and appropriate in the circumstances. Now, once you've determined your annual income, round it out to the nearest $100 amount and then go to the tables to see how much you have to pay every month. What if you and the other parent want to reach your own private agreement on the amount of child support that should be paid? You can do it, and you have some flexibility about the amount that will be paid, as long as you agree and the amount is fair. Many parents use the child support tables to help them come to an agreement on their own. But please be aware, if a judge is asked to decide, the judge must set child support amounts according to the rules in the child support guidelines. If the support recipient is in receipt of social assistance, or what some people call welfare, she or he may have assigned the support monies to the government agency that is paying the social assistance, in which case any agreements would have to involve that agency. There's 4 situations where you may not have to pay the table amount. The first is if the child is an adult. Once a child reaches the age of majority, the court is not bound to apply the table amount, although I must say that in most cases the table amount is applied. But there are cases where an adult child who's a full-time student works part-time or in the summer or has funds to help pay for his or her education, maybe from an RESP, or has some other source of income. If the court is of the view that it would be inappropriate to apply the table amount, the court can order a different amount, taking into account the financial circumstances of the parents and the adult child. The second situation where the table amount does not necessarily apply is if the support payer earns over $150,000 a year. As a general rule, the table amount is presumed to apply, and if the payer wants to pay less, he or she would have to satisfy the court that it would be inappropriate to order the table amount. The court, in that situation, will look at all of the circumstances, including the family's lifestyle before and after the separation, the parties' financial situations, and the children's reasonable needs. And although I think it's fair to say that a payer may have an uphill battle if he or she wants to pay less than the table amount, there have been cases where the court found that it would be inappropriate to order the table amount, and so a lower amount was ordered to be paid. The third situation where the table amount may not necessarily be ordered is if the support payer is not the biological or adoptive parent of the child. In other words, if the support payer is a step-parent. In those cases, the court will usually start with the table amount and then look at all of the circumstances to determine what would be a fair and appropriate amount to pay. Obviously, the court will want to know how long the step-parent relationship lasted and whether the biological parent is paying child support, whether the step-parent has other children to support. The court will also look at the financial circumstances of all of the parents. There's more information about step-parents' obligations in Chapter 8 of my book, Tug of War. The fourth situation where the court may divert from the table amount is if the payer can establish what we call undue hardship. This is a very difficult and complex two-part legal test that has to be met, and I can only give you the bare bones here. In the first part of the test, the payer has to fall within at least one of the following set of circumstances. The payer's been left with an unusually high amount of debt that was reasonably incurred to support the family when the family lived together, or to earn a living. The payer lives far away from the child and has unusually high expenses to exercise access, usually traveling expenses. The payer has a legal duty to support another spouse or a child. But here's the kicker. Even if you fall within one of those three situations, you have to prove that you would suffer undue hardship if you had to pay the table amount. It may be easy to prove that you'd suffer some hardship, but it's really hard to show that the hardship is undue, because the law expects parents to put their child support obligations first in their list of financial priorities. And here's an even more important kicker. Even if you are able to prove undue hardship, your request to pay less than the table amount will be denied if the standard of living in your household is higher than the standard of living in the other parent's household. How do we measure the standard of living in each household? Well, there's a formula in the child support guidelines, and there are computer software programs that can help with the calculation. But trust me, it's complicated. If you're wondering whether your particular circumstances might allow you to pay reduced child support because of undue hardship, please go and see a family law lawyer before you get your hopes up. I can tell you that it is extremely rare for an undue hardship claim to succeed. Now let's look at some other situations that might result in a diversion from the child support tables. The first is the split custody situation, which means that each parent has custody of at least one child. In other words, the children have been split between the parents. In that situation, you have to look at the amount of each parent's annual income and then go to the tables to see how much each parent would have to pay the other. And whoever earns more will have to pay the other parent the difference between the two amounts. Here's an example. Let's look at the Ontario tables again. Assume that parent A has one child and parent B has one child. Parent A earns $25,000, so parent A would owe parent B $211 per month. Parent B earns $30,000 a year, so parent B would owe parent A $270 a month. The difference between $270 and $211 is $59 a month. So that's the amount that parent B would have to pay to parent A. Here's another situation that sometimes comes up, and we call it shared custody. If the child is spending at least 40% of the time in the actual physical care of the support payer, then the court can order an amount of child support that's different from the table amount. But I'm sorry to tell you that this too is a very complicated and difficult part of child support law. First of all, it's not that easy to calculate the percentage of a child's time that is in each parent's actual physical care. Because many times children are not in the actual physical care of either parent. They're at school or daycare, or they might be involved in extracurricular activities. Secondly, it's by no means true that child support will be automatically reduced if a child spends more than 40% of his or her time with the parent who pays child support. Not every dollar spent on the child by the access parent means a dollar saved by the custodial parent. The goal is for the child to enjoy the same standard of living in both parents' homes. The court has a broad discretion to look at all of the circumstances, including the parent's incomes, the child's needs, and the real cost to each parent of the shared parenting arrangement. And at the end of the day, the court has to come up with a fair apportionment of each parent's contribution to the support of the child. In cases where an access parent is seeking a reduction in child support because of what we call the 40% rule, the court will often require each parent to produce detailed budgets showing the actual child care expenses to each parent. If you're wondering whether your parenting arrangement with the other parent would fall within this 40% rule, you should definitely consult a family law lawyer. Now, in addition to the table amount of child support that must be paid every month, there can also be what we call special or extraordinary expenses, which each parent must contribute to. Some examples: daycare, health-related expenses such as prescription drugs, dental care, university and college tuition fees, and of course, extracurricular activities like hockey and summer camp. Not every extracurricular activity will be considered an extraordinary expense. After all, every child is expected to have some extracurricular activities. Whether an activity falls within the definition of extraordinary expense will depend on the cost of the activity, the means of the parents, the needs of the child, and any other relevant information. Special expenses must be necessary, in other words, in the best interest of the child, and the cost has to be reasonable when looking at the parent's financial circumstances. A custodial parent is expected to consult with the other parent before enrolling the child in an expensive activity, especially if you expect the other parent to contribute to the cost of that activity. That's only fair, don't you think? If you're wondering how we calculate the amount that each parent has to pay for a special expense, the formula is easy. Each parent pays a share of the cost in proportion to his or her income. Here's what the formula looks like. You take the payer's income, divide it by the total combined income of the parties, and multiply that figure by the cost of the special expense. That will give you the amount that the support payer will have to contribute for the special expense. And one more thing. If you're talking about daycare, the payer's contribution to the cost of the daycare would have to take into account the tax deduction available to the custodial parent on account of the child care expense. So the bottom line about special expenses: first, you need to have proof of the cost of each expense. For example, the bill from the dentist or the receipt from the daycare center. And you have to have proof of both parents' incomes. And you have to be sure that the expense that you're claiming is for an appropriate special expense. If you have specific questions about any extra expense that you're paying for your child, and you're wondering whether it qualifies as a special or extraordinary expense, consult your lawyer. One final word about child support. As you know, the amount is based on the payer's income. Most people's income changes every year, and every time a support payer's income changes, the amount of child support will change. And so, if you're a support payer, it is very important that you provide the other parent with a copy of your income tax return and notice of assessment every year so that the amount of child support can be adjusted. If this is not done, you may find at some point in the future that a court is going to go back and retroactively change your child support to reflect your income for every year since your support amount was originally set. And believe me, that can be very problematic. So it's best for parents to keep on top of support obligations. How long do you have to support your children? Well, if you and the other parent have a support agreement, you should see what the agreement says about the duration of child support. If you have a court order, then the duration of child support will depend on the statute under which your order was made. Your order might have been made under the Divorce Act or under a provincial statute. Generally speaking, the law requires parents to support their children for as long as they remain dependent. Usually, this means until they graduate from full-time school. But sometimes a parent will be required to support an adult child who's unable to withdraw from parental control because of a medical condition or a disability. If you're unsure about how long you have to pay child support, you could try asking the government support enforcement agency responsible for collecting your child support. And of course, you're always well advised to consult a family law lawyer. Now, I want to repeat to you what this broadcast was intended to provide, and that is a general overview of the basic law governing child support. I'm sure that we will be doing other shows regarding various aspects of child support, but I wanted to give you this presentation right away at the beginning of the series because I know how confusing it can all seem. And so, I hope that the information that I've given you will point you in the right direction and at least give you some familiarity with the basic concepts. But remember, if you have specific questions about the law in your area or about your rights and obligations, your best bet is to consult a family law lawyer. Thank you, and see you next time.